For the record, in the action entitled Machinists, Local Lodge 1061 versus State of Wisconsin, 15 CV 628. Would you state the appearances, please?
For the plaintiffs, Your Honor, my name is Fred Perillo from the Previent Law Firm, and with me is my colleague Aaron Medeiros.
On behalf of the defendants, my name is Stephen Kilpatrick, Assistant Attorney General with the Wisconsin Department of Justice, and with me is Daniel Lennington, Deputy Solicitor General.
The case is on the calendar this morning for a hearing on the state's motion for a stay of my judgment, I guess, pending appeal. Let me get things turned on here. It's your motion, Mr. Kilpatrick.
Thank you, Your Honor. And do you mind if I remain seated? I think the microphones work better.
Whatever is most comfortable for you. I don't have rules on that.
Okay. Thank you, Your Honor, and thank you for scheduling this hearing on defendants' motion for a stay of the court's judgment. The defendants have set forth in briefing 4 factors that our Supreme Court has stated should be considered before issuing an order on the motion for stay. And that is, I'm happy to tell you, the one place where the parties agree. The rest, we believe we have met the factors, and I'll go into those. A stay pending appeal is appropriate where the moving party, 1, makes a strong showing that is likely to succeed on the merits of the appeal. 2, shows that unless a stay is granted, it will suffer irreparable harm. 3, shows that no substantial harm will come to other interested parties. And 4, shows that a stay will do no harm to the public interest. Now, these are factors that are not prerequisites. They are interrelated considerations that must be balanced together. So more than one factor excuses less of the other. But again, defendants submit that they have met all of them. The first, the defendants are likely to succeed on the merits of the appeal. We have cited Gudenschwager, the Supreme Court decision, in support of this factor. We believe this is controlling authority, and plaintiffs' reliance on Gudenschwager is misplaced. In that case, the Supreme Court understood that regularly enacted statutes are presumed constitutional. And this alone was enough for the court to hold for the state, the moving party, that it had made a strong showing that is likely to succeed on the merits of the appeal. This case is the same. Portions of Act 1 that this court found unconstitutional are entitled to a presumption of constitutionality on appeal. So the plaintiff's reference to an Eastern District decision from Michigan, Gruder versus Bollinger, is not binding authority. It's misplaced. Gudenschwager is. This factor, therefore, weighs in the state's favor. And despite what plaintiffs wrote in their brief, defendants do not believe that this factor alone entitles them to a stay. But the defendants contend that they have met all the factors, even though they are not required to. So the first factor, I believe, weighs in the state's favor. Second factor, unless a stay is granted, the defendants will suffer irreparable harm. Now, the court's judgment enjoined defendants, State of Wisconsin, Attorney General Schimmel, and 2 of the commissioners of the Wisconsin Employment Relations Commission from enforcing certain provisions of Act 1, including but not limited to the provision making it an unfair labor practice to require, as a condition of employment, dues and fair share payments from employees in collective bargaining units that the plaintiffs represent. But every day that the defendants know that they will not be able to enforce portions of Act 1, a law enacted by the representatives of its people against the plaintiffs, is a form of irreparable injury. We have cited 2 decisions from the Supreme Court justices, and we did not cite these decisions as binding authority on this court. They were decisions written by two justices as persuasive authority who believe that any time a state is prohibited from enforcing its laws, that is a form of irreparable injury. And on those cases, we will rely. Plaintiff's argument that the law finds irreparable harm when the court finds a statute constitutional ignores the principle here in Wisconsin that all regularly enacted statutes are presumed constitutional on appeal. Plaintiffs also discuss injunctive relief as a matter of right in a takings case, but this statement is misleading. Defendants are not challenging an injunction today. That was litigated before defendants were unsuccessful. Today, defendants are seeking a stay of the injunction. On to the third, a stay will not harm the public interest. This is related to the second I discussed. But here the parties disagree on the meaning of the status quo. Defendants believe that the status quo is the Employment Peace Act as amended by Act 1 over a year ago. The status quo is in which new collective bargaining agreements have been entered into in respect of Act 1. The plaintiffs ignore the status quo across the United States. Since the 40s, there have been right-to-work laws in the several states in the Union. Congress has given its approval to these laws. None of them have been held unconstitutional by an appellate court during that time. This is the status quo that needs to be respected by this court staying its judgment. And the public interest will not be harmed in a stay. The public interest is not served by Act 1 going into effect for a year and then a year later being unenforceable against plaintiffs by certain state officials. This can create confusion around the state as to whether Act 1 is in effect and what can and can't be included in a collective bargaining agreement. Who must follow Act 1 is a question. Prior to the court's judgment, but after summary judgment, Secretary Treasurer of AFL-CIO Wisconsin, a plaintiff here, as quoted in the State Journal, said it was no longer illegal in the state to negotiate over fair share agreements. There may be employers who disagree. But the question of whether this court's judgment has statewide effect is not why we're here today. What we have said is that there may be confusion across the state, but it is certainly clear that our Supreme Court has said that issues of constitutional questions cannot be fully laid to rest until a published decision of the Court of Appeals or a Supreme Court decision. And that leads me to our final factor, which is the plaintiffs will not suffer substantial harm if a stay is issued. And I note at the beginning that substantial means large in size, value, and amount. And the plaintiff's own affidavits filed in this case that are in the record show that they have not suffered substantial harm and are unlikely to during the pendency of the appeal, which should only take a few months. Plaintiffs say that their losses are mounting, but the evidence shows otherwise. In the O'Connor affidavit, only 4 employees in a bargaining unit are not union members who have said that they are not going to pay dues or fair share. This amounts to a little over $2,000 per year. But again, the appeal will not last that long. And Mr. Hoekstra's affidavit filed in the motion for temporary restraining order, if I'm reading it correctly, stated that there were 102 employees in that collective bargaining unit. And that's just a 3.9% of the unit not paying dues. That is not substantial. And in Mr. Winklebauer's affidavit, he testified that there were 73 employees in a unit at employer Rexnord, and only 6 had resigned as of the last year and said they would not pay dues. This is a loss of about $4,200 a year if no more withdrawals from membership and no new persons join. This is only an 8.2 loss of revenues from dues. Again, that is not substantial. And as to a bargaining unit at Russell Metals, 3 out of 46 resigned from the union for a loss of $1,856 per year, 6.5% loss in revenue. Again, not substantial harm. But most importantly, Your Honor, these affidavits refer to past arbitrations regarding grievances of employees, but none show that any non-paying employees in the unit have filed grievances which are going to arbitration. There's nothing in the record showing that. And this is very important because this is what plaintiffs' taking theory challenge is all about. It was one, that they were not getting dues payment, but two, that they needed to represent all employees in the unit, even the members who weren't paying, and that was a taking of their private property. But the absence of any proof of any taking injury at this time means that there's no substantial harm to the plaintiffs and there won't be pending a short appeal. And in fact, this court, in denying plaintiffs' temporary restraining order, found that there was no evidence of irreparable harm or likelihood that the plaintiffs would suffer. So that is a discussion we had previously. So in conclusion, Your Honor, defendants have met all the factors that the Supreme Court said must be considered in a motion for stay. But even if this court does not agree that the defendants have met all the factors, we believe this court should balance the factors in the favor of the defendants. And on that basis, we ask that the court grant our motion and do so today from the bench. Thank you.
Thanks, Mr. Kilpatrick. Mr. Perlow, is it you or?
Yes.
Ms. Madera?
Good morning, Your Honor, and thank you. The state's position is quite breathtaking. If you take it literally, the state is saying that because all laws of the state are regularly enacted, if you ever declare any of them unconstitutional, they would automatically be presumed to have a success on appeal and automatically be presumed to suffer irreparable harm. There would be no balancing test. The test would always incline in favor of enforcement of a law that the court has found to be unconstitutional. I say it's quite breathtaking because literally the state means if they pass Jim Crow laws, those laws would be regularly enacted, they'd be presumed constitutional, and the state would be presumed to suffer irreparable harm. So even though they were obviously unconstitutional, you would enforce Jim Crow under the state's theory. That shows that there's something wrong with the way the state is applying the test. Let's look in detail at why it's wrong. I think everyone acknowledges that the key factor is irreparable harm. The test is very deliberately worded that the defendants must show that they are the ones who are going to suffer the irreparable harm. There is, in fact, no showing whatsoever of harm to the state, just the presumption that the state suffers harm automatically when a statute cannot be enforced, even if it's unconstitutional. The statement by Justice Rehnquist, to which the state has referred, has actually never been adopted by the Supreme Court as law. Similarly, the Ninth Circuit decision that the state relies upon was later rejected by the Ninth Circuit for the reason I just gave, that it, in fact, in the Ninth Circuit's words, eviscerated the balancing test. It's also fundamentally at odds with the requirement that injunctive relief be a right, as announced by our Supreme Court in Schuster. It's meaningless to have an injunction that is automatically stayed. That's like not having injunctive relief. The state makes no attempt to show that it will suffer any actual harm, in contrast to the Gutenschwager case, where there was a sex offender, where there was evidence that the sex offender, if not restrained, would be likely to go out and commit more acts. There was no place to put the sex offender, and the sex offender had declined treatment. That's a very compelling showing of irreparable harm that goes beyond just a presumption. There's no such showing here. There are only two possible harms that the state could enunciate. The purported justification for Act 1 was that there would be harm to the state's business climate. For 70 years, Wisconsin was not a right-to-work state. There's absolutely no evidence that was presented at any point in these proceedings that the state business climate suffered for that, and anyone who lived through that period knows that the state business climate improved or declined in accordance with the business cycle just like it did for all states in the nation, whether or not they're right-to-work states. There's absolutely no evidence presented by the state that in the past year, when the right-to-work law was in effect, the state's business climate improved dramatically better than that of other states, both right-to-work states and non-right-to-work states. In fact, if you own a newspaper, you know that Wisconsin's business climate is rated as one of the worst in the nation and did not improve during the year that right-to-work was in effect. This is not a rational basis test where the state gets to declare if it has any basis there's a connection between the law and the improvement in the state's business climate. The law has already been determined as unconstitutional. We're now trying to determine whether the state can demonstrate actual harm, and there just isn't any evidence presented by the state of actual harm. The state also cannot rely on the harm to the non-union members who want to continue to receive free services, as it attempts to do in its brief. For one thing, they are not the defendants, and for another, non-member employees don't have a constitutional right to have free services provided at the expense of other people's constitutional rights. Presumably, the state has an interest not only in the enforcement of state statutes, but in the enforcement of the state's constitution. And it's somewhat odd that the Attorney General is arguing against the enforcement of the takings clause, in effect saying, even though you have found that this is an unconstitutional taking, you ought to permit the unconstitutional taking to persist for an indefinite period of time. It is, in fact, for this reason that the state has been unable to cite even one takings case in any jurisdiction where a court has ever allowed an unconstitutional takings once found to persist. I've cited you the Monsanto case and the Third Ave case where specifically, despite strong governmental interests, including in Third Ave, international treaty obligations, or in Monsanto, the regulation of pesticides, the government's interest had to bow before the unconstitutional taking. The next factor is whether there is harm to the plaintiffs and to other third parties. The state here has attempted, and if you listened carefully, Mr. Kilpatrick said at the end of his argument that plaintiffs have failed to prove that they will suffer harm. That, of course, is not the test. The test is whether the state proves an absence of harm to the plaintiffs and to other third parties. The state has not done this. First, there are three potential kinds of harm: the monetary loss, the inability to negotiate contracts that will contain union security clauses, and third, the enforcement of contracts that have snapback clauses in them that allow union security to pop back into existence. I think the court will recall a year ago when we had the argument on the preliminary injunction, which I lost. The state argued that there was no irreparable harm to the unions because we could negotiate snapback clauses that would allow union security to pop back into place if we won. We did. Now we've won. And the state's response is, you actually can never enforce those clauses that they argued a year ago prevented us from being irreparably harmed. If you add those things together, you actually do get irreparable harm. The state has not indicated how we will recoup the losses we have actually suffered or the losses we surely will suffer. As the court noted in its opinion, the state is not opening its coffers. We have no right of action against the individual employees who did not pay. And so we are going to incur monetary losses of thousands of dollars that will go indefinitely into the future. We have no way, if this decision is stayed, to negotiate contracts that provide for union security going forward into the future, because the law would prohibit that. And according to the state, we cannot enforce our snapback clauses. So in fact, all of those harms not only would be cemented in place by a stay, but would in effect become irreparable harm. The harm is not only to the plaintiffs here, but to every private sector union in the state. According to the Bureau of Labor Statistics, there are approximately 223,000 private sector unionized workers in Wisconsin. That's a substantial group of people who are suffering an unconstitutional taking. There are about 253,000, again, according to the Bureau of Labor Statistics, 253,000 workers in those same establishments. So approximately 30,000 non-union workers working in establishments with 223,000 unionized workers. The state is arguing that indefinitely going forward, we ought to continue to subsidize those 30,000 workers by the taking of our property. The state has not articulated a reason why that ought to be true. Apart from the presumption, the state cannot identify any reason why it has a likelihood of success on the merits. All of the arguments that it made in its brief are arguments that were presented to you and rejected by you already. There hasn't been any intervening change in the law, and the state, for some reason, persists in saying there are no cases or statutes supporting any of our positions on the taking, even though obviously there are. For example, the state persists in saying that unions don't have to be exclusive representatives, even though, as you cited in your opinion, there's a specific state statute that says that. The state continues to say we have the, quote, wrong relief, although as we just saw, the state doesn't believe we can get any relief, despite the fact that there's a specific Wisconsin Supreme Court opinion on point saying we are entitled to injunctive relief. The state, in fact, claims to have found sort of a unicorn in the law. Article 1, Section 9 of the Wisconsin Constitution says there is no legal wrong without a remedy. But the state says this one has no remedy. You can't get the money back. You can't negotiate future contracts. You're not entitled to an injunction. You can't get a declaration that's enforceable. The takings, in other words, is something that in this case the state says we simply have to suffer, even though it is unconstitutional. Again, a breathtaking position for an attorney general who's also charged with the enforcement of the state constitution. Finally, Your Honor, regarding the public interest, the state again attempts to rely on the harm to the non-member employees in its brief, but the non-member employees aren't entitled to take the property of other people merely because in the past year they have become accustomed to receiving free services. That's not an enforceable legal right. If it were, I mean, those non-member employees would have sued 70 years ago to demand the free services when Wisconsin was not a right-to-work state. That never happened, and that's because there is no such constitutional right to receive free services. Similarly, the state's argument that the public interest is not harmed by allowing the takings to persist because the law is presumed constitutional or they are presumed to have irreparable harm, it's really just a restatement of the first two factors. The reality is the state is harmed whenever the Constitution is allowed to be flouted without a good reason, and the state hasn't presented a good reason. In summary, Your Honor, the key factor, irreparable harm to the state, is completely missing of any proof. There isn't any evidence that something bad is going to happen to the business climate of the state of Wisconsin if during the course of this, what the state argues will be a brief appeal, there is a temporary suspension in the right-to-work law, even assuming that they win at the end of that case. If so, if it takes less than a year to get that appellate decision, surely that is balanced by the year where we now know unconstitutionally our property was taken every day without any possibility for us ever to recoup those damages and without any possibility to enforce contracts that should have been legally enforceable. the stay should be denied. Thank you, Your Honor.
Your Honor, may I have the last word? It's our motion.
You do.
Great.
Well, you get the penultimate word.
Thank you, Your Honor. Just a couple of comments. One is the plaintiffs bringing up the Jim Crow laws is just disingenuous. The state never said, defendants never said that every factor had to be met. The beginning of my presentation here is that these factors are interrelated. They're not requirements. So there is a balancing of the interests, and we've never said that we have to meet all of them. It's a balancing of the interests. So the Jim Crow example is just disingenuous. The plaintiffs keep on bringing up the purpose of Act 1 being improve the business climate to the state. That is nowhere in the text of Act 1. That is a plaintiff-driven argument that was taken from, I believe, lawmakers, maybe on the floor, in passing Act 1. It may be a purpose of Act 1, but it is not the purpose of Act 1. There is no written policy purpose of Act 1. But if you read Act 1, certainly there must be a purpose of giving non-member employees a choice whether to pay dues, whether to pay fair share or not. Some may not. But that certainly is one of the choices and the policies of Act 1, whether plaintiffs want to realize that or not. Plaintiffs also said that there's no constitutional right to take the property of another, but there's also no constitutional right to the dues or fair share payments of non-members. That is clear from U.S. Supreme Court precedent. And again, the plaintiffs keep talking about our property was taken every day. Non-members take money from the members. That is incorrect too. Their entire theory was based on two prongs. One, that no income was coming in, but importantly, two, the expenditures. It was not a taking of property every day non-members don't pay in. It was the taking, they argued, is when they were forced to expend money on non-members. That's the taking. Please don't let them say otherwise here and persuade you otherwise. And again, in the balancing of the interests, the balancing of the factors, we believe that the defendants have met those requirements, and the balancing requires a stay of this court's judgment. We're not asking this court to reconsider its injunction or its declaration. It's a motion for stay. That's different. We're simply seeking a stay pending appeal. Thank you.
Thanks, counsel. I may have neglected to push a button here. Can you hear me? Did I just turn you off? So that button does nothing. The lawyers accurately cite the four factors that a trial court is to consider in evaluating whether to stay a ruling pending appeal. For years, it struck me as curious that the first factor is described as likelihood of success on appeal, because what trial judge thinks that he or she is likely to be overturned? But nonetheless, that's the first factor. The four are to be weighed and balanced. There's no mathematical rule about how much of one you have to have. The state argues that the heavy presumption of constitutionality of a statute demonstrates their likelihood of success. The defense counters that, well, it can't be the case that any enactment of a statute is likely to succeed. I don't think they're disingenuous in citing the possibility of Jim Crow laws. It's a factor that has weight, it deserves weight. It is certainly true that an enactment of legislation is entitled to a presumption of constitutionality. That presumption carries great weight, and it carried a lot of weight with me as I considered whether to rule in the manner I did. The decision perhaps boils down to something as simple as there is no free lunch, there is no right to be a free rider. As I wrote the memo that I wrote regarding the form of the judgment after the parties quarreled a bit about just what form the judgment ought to take, one of the things I came across was the 1954 decision of the U.S. Supreme Court in Radio Offers Union versus Labor Board at 347 U.S. 17. And as far back as 1954, the Supreme Court spoke of the 1947 work by Congress in amending the act, saying, this legislative history clearly indicates that Congress intended to prevent utilization of union security agreements for any purpose other than to compel payment of union dues and fees. Thus, Congress recognized the validity of unions' concern about free riders, that is, employees who receive the benefits of union representation but are unwilling to contribute their fair share of financial support to such union. As recently as the 90s, in a 1991 decision, which involved public unions, the U.S. Supreme Court in Lehnert, L-E-H-N-E-R-T versus Ferris Faculty Association. This is at 500 U.S. 507 at page 50. Page 507. The Supreme Court hang on, let me get to the right place. This is at page 519. I think it was Justice Blackmun wrote the opinion. He wrote thus: although the court's decisions in this area prescribe a case-by-case analysis in determining which activities a union constitutionally may charge to dissenting employees, they also set forth several guidelines to be followed in making such determinations. Citing a couple other cases, those cases and their progeny teach the chargeable activities must, 1, be germane to collective bargaining activity. 2, be justified by the government's vital policy interest in labor peace and avoiding free riders. That language catches my eye. A vital policy of the government's vital policy interest in labor peace and avoiding free riders. I think there's weight of opinions over time and congressional activity over time that speaks to the issue that's at the heart of this case, and is not about a right to work, and it's not about a right to join or not join a union. It's about whether or not a non-member has an obligation to pay for the services they receive, or whether an entity can be required to provide services at no charge to someone. And I think there are years of weight in support of the decision that I reached. I don't think that there's a likelihood of success that causes me to think, oh, I ought to just put this on hold while the appeal runs its course. The second and third factors have to do with irreparable injury to the state and whether there's substantial harm to others if there is a stay. In its brief, the state identifies two components of public interest in play here. One is the non-members' freedom to choose whether to join or not join a union, and the second is preservation of the status quo. In terms of injury to the state, harm to the unions, the state does talk about, well, the state is always injured if a law is declared unenforceable. The state doesn't, there's no evidence that the state suffers one way or another. The battle lines here are between non-union members who would not be required to pay for the services they proceed, which I think, Mr. Kilpatrick, go beyond arbitrations, but go to negotiation and simple contract maintenance, and whether the unions suffer harm by virtue of those fees not being paid. And I think it's fair to look at this as balancing a small injury to a large number of people to a larger injury by a small number of organizations. And I don't think, assuming I get reversed, the current non-members who are required to pay for the services they receive is not very significant irreparable harm compared to the size of the loss to be suffered by the unions if they're required to provide services without fees from non-members who, by this legislation, are excused from paying. The fourth factor has to do with a stay and the public interest. I spoke earlier, the public interest identified in the state's brief. They talk about the non-members' freedom to choose whether or not to belong to a union and the preservation of the status quo. I repeat, this case is not about somebody's freedom to join or not join a union. Union membership is not required by the law prior to right to work. Right to work doesn't save anybody that. What the legislation does is it enables people to receive services from an entity without having to pay for it. It's not about union membership. And preservation of the status quo, as Mr. Perillo, I think, aptly points out, is the status quo the last 12 months, or is the status quo the last 70 years? this is not a case about 100-year-old oak trees with bulldozers lined up on the edge of the road, ready to take them down, never to be replaced. This is a stay that has to do with the payment of fees to entities that do work for the people who right now get those for free. I've enjoined that. I don't think it harms the public interest to say that, as I've said before, there isn't a free lunch. You're not entitled to a free ride. I think the factors weigh in favor of maintaining the decision. I don't think that they tilt in favor of staying this pending appeal. I don't voice any opinion about the likely duration of the appeal. I'll deny the motion for stay. Do you want to draft an order, please, Mr. Prillo?
I will, Your Honor.
We are adjourned.
Thank you, Your Honor.
Sure.